So the first chapter that we're going to deal with today with respect to law of contract is of course the introductory chapter, which talks about formation of a contract. Just as I was telling earlier before we begin with this class, I was talking about contract being a part of our lives, our daily lives, and I was talking about how even when you go to the store and even you purchase an ice cream, knowingly or unknowingly, somehow you enter into a contract. You don't even realize, but there is a contract. When you hire the services of a maid, there is a contract involved there. So contract can be verbal or it can be even written. So, contract law, what is this contract law? So, law pertaining to contract or which governs the principles pertaining to contracts is called the law of contract. So, contract law is basically one of the most important legal concepts in the world of business. And contracts, determine everything like how trade is done, how companies interact with each other, how they coordinate with each other, how they cooperate with each other, how they trade with each other, how countries trade with each other, and it talks about even employee contracts, that is how employees are hired, how the companies would work together, how sales would be done, how supply transactions would be done. So all of it is governed by contracts in the corporate world. Now, what is this contract? If I ask you what is a contract in simple terms, I'm sure you would say that is a kind of an agreement where two or more parties agree with each other on certain terms and conditions, and on certain terms and conditions relating to a particular transaction or that would govern their relationship. So, talking about contract, if you're talking about the law of contract, a contract in legal parlance is a legally binding agreement between parties to create mutual obligations that businesses and individuals they use to protect their interests. Why? Because they want to protect their rights. Each party who enters into a transaction with another wants to, protect their rights. Like if I give you a simple example, I'll reiterate the same example that I gave earlier. That is, you hire the services of a maid for your house. What do you do? How would the maid girl protect her interest? Uh, it would be like, okay, she would take an assurance from you that yes, that you will be paying her a fixed amount of money, whether it's weekly or daily or monthly, depends what is the understanding. Then she would assure that she should be protected, they should be, treated well as per the law. She will do the work for a particular number of hours, legally permissible, say around 8 hours, legally permissible, or even lesser number of hours if you want her to work for lesser number of hours, and the type of work that she is expected to do and what should be done. And of course, the type of work should be legal. Domestic workers, it will be legal. But again, for example, if there is someone who contracts the services of a maid or even a servant or a valet, and then tells them, okay, fine, you do all these work, but apart from that, you discreetly or ask him or her, you in the sense, any person for that matter, says, okay, go and deliver drugs to somebody. Now that is illegal. That cannot be contracted. That is an illegal contract. So, keeping ourselves within the purview of legal contracts, and giving you a simple example of a legal contract would be to hire the services of a maid, where she would protect herself by ensuring that you pay her the amount of money that she is expecting as her wage, and her rights are protected. And you would see your rights would be protected in what sense? Where you would see, for the amount you're paying, the services that she undertakes should be to your satisfaction and to the level of satisfaction that you expect from the hired servant or the hired worker. And those are some of your rights, that you pay the amount you're paying, the services you are getting back. And it should be done neatly and as per your instructions and so on. So this is a simple example. Yet another example is the most simple example I would give you again is, you go to the store, to the ice cream store, and you purchase an ice cream. Now, how there is a contract that you don't even know that there is a contract here? There is an open offer. There is a store. There's an open offer. Okay, you're getting a particular ice cream for, say, whatever currency it is. Like, say, if I talk about whatever, say, dollars, you're getting a very good ice cream for a particular $1, for example, $1. So it's a Sunday. So there's an open offer. There is a board there outside the ice cream store, and you see those delectable pictures, and you say, wow, okay, let me go and fetch an ice cream. And that's an offer. So you go and you see the price there and you pay the price. So now, in this example, there is an offer by the store. You accept the offer by entering the store, asking the store person or whoever is there for the ice cream. You accept the offer. So offer plus acceptance becomes an agreement. That means there is an offer on the part of the storekeeper or the ice cream vendor. You accept the offer. First, you ask for the price. He says $1 for the sundae, and you accept the offer and say, okay, give me that. So there's offer plus acceptance. Now here there is an agreement. He gets it ready for you and you pay the price. The price is called consideration. I'm repeating. The price that you pay in legal contractual parlance, we call it consideration. So this is the concept of consideration. You're paying the price, $1. That is the consideration. Offer, what is offer here? The store is open. That's an open offer. There's an offer. Come, I'm an ice cream store. Come and purchase ice creams from me. You enter the store, you ask for the price, you ask for the particular ice cream or sundae. They give me the sundae, and you ask, what is the price of it? $1, ma'am or sir. Okay, fine. Give me that. You say, give it to me. Fine. You agreed. Offer plus acceptance is an agreement. Then they get the sundae ready for you, and it's put up on your table or whatever. You pick it up, or you whatever, whether you eat it there, you take it along with you, whatever it is. So you take it, and so there the contract comes to culmination. I mean, it goes towards the end where you are paid the price. Consideration is paid. So when the consideration amount is paid, and there are some other additional factors as well called enforceability part of it. So when this agreement becomes enforceable, it becomes a contract. So let me tell it to you in simple words. Offer, let me give it to you as an equation. Offer plus acceptance is an agreement. Just put it as an equation. Just make notes. Offer plus acceptance equals agreement. Now take this agreement out. Agreement plus enforceability equals a contract. Now, what makes this contract enforceable? What makes the agreement enforceable? I'm sorry. What makes the agreement enforceable, and how can you call an agreement a contract? It should contain certain elements. What are they? There should be a consideration. Consideration may be in the form of money. In your case, you paid the price of $1 for the ice cream. That's a price. That's consideration. Then it must be, not in this example, but for a contract to be legal. I'm talking about commercial contracts now again. For commercial contracts to be considered legal, or even any contract to be considered legal, it has to be by a person who's got capacity to contract. Now, who's got the capacity to contract? A baby cannot contract. A toddler cannot contract. Can they? They must be, or they must attain the age of majority, right? So a toddler cannot contract. An insane person, It cannot be considered as a valid contract if a person is insane, is out of mind, is medically considered as incapable of understanding things, or is imprudent, or cannot understand things, is insane. Yeah. So the party should be competent to contract. A person should be competent to contract, should not be a child, toddler, insane, suffering from some mental disease. Yeah. And so on and so forth. So this is capacity to contract. So agreement, so offer plus acceptance is agreement. This agreement, which is topped up with enforceability, or the factors of enforceability, or capable of being enforced. Therefore, agreement plus enforceability is called a contract. So therefore, we say all contracts are agreements, but all agreements cannot be considered as contracts. Why? Because agreements which are enforceable are contracts. Without enforceability part of it, they are considered as agreement. However, in our day-to-day business, sometimes we do use the word, we interchangeably use the word agreement and contract. However, theoretically speaking, and for the purpose of legal understanding, an agreement which is enforceable is a contract. Okay? Now let's move on to our slides. Do you have any questions here? Okay, so I presume you understand. Okay, so this is a practical subject. Okay. Now, here, today, most areas of our lives are governed by a contract. Contract refers to arrangement between parties who desire to govern their relationship and a specific dealing or transaction on mutually agreed terms which may be expressed either verbally or in writing. Therefore, contract involves agreement between parties to be governed by a particular set of terms with the intention that in case of breach of those terms, the breaching party may be made accountable for the act of breach, including the losses that may be caused as a result of such breach or contravention of the terms agreed and set forth in the contract. That means the parties contracting with each other must comply with the terms of the contract, and there mustn't be any breach of those terms. And in case of breach, the parties are entitled to knock the doors of the court. First thing is, of course, there would be the relief that would be given by the court, a specific performance of contract, which we'll be learning in a separate chapter. Of course, that's a different chapter altogether, but just by way of introduction, I'm telling you that when there is a breach of contract, the first relief that is available to the party is specific performance of the contract. Say the court will order the other party that is breached, okay, come on, perform your part. They would give an order saying, okay, perform your part. So that would be specific performance of a contract, or some other reliefs could be different kind of reliefs. It depends. We will study in the forthcoming chapters about what are the reliefs that are available, or how to address and redress breach of contracts. It could be specific performance, there could be injunction, they can be damages, and so on. Okay, that we will deal with later. Next is, thus a contract involves agreement. So agreement may be defined as an offer that is accepted. Thereby, there are two elements in an agreement: an offer plus acceptance of that offer. So offer plus acceptance is agreement. Now, an agreement that is enforceable in law is a contract. That means agreement. What is an agreement? Offer plus acceptance. Now, take this agreement part of it and say agreement plus enforceability. ENFORCEABILITY. Enforceability equals a contract. So an agreement that is enforceable in law is a contract. An agreement with no intention of enforcing it will not culminate in a contract. So the factor of legal enforceability therefore makes an agreement a contract. Therefore, we could say that all contracts may be agreements, but not all agreements are contracts. Now, if a question comes for your exam, all contracts are agreements, but not all agreements are contracts. You will have to give me the definition of an agreement. You'll have to give me the definition of contract. You'll have to give me all the factors of enforceability that you will be studying in this chapter and the forthcoming chapters. So all the elements, what makes an agreement enforceable, all those elements which we'll be studying henceforth in the other chapters, that will complete this answer. Which answer? All contracts may be agreements, but not all agreements are contracts. Now, for example, A invites B for a dinner. That's offer. B agrees to accept the invitation. So there's offer, the offer is accepted. So it's agreed. That's an agreement. Now, this example clearly sets out an offer which is accepted. But here, now say B has an urgent work to attend to and does not turn up for the dinner. So the question is, can A sue B for the damages? Now let's put it this way. You invite me for dinner. I say, yes, I'm willing to come to your house. Surely I will be there. Finally, you get all the dinner ready and you say, not only you come along with your family. And I'll say, okay, we are 4 of us. So, okay, plus 4. Okay. So you prepare for, apart from your family, additional 4 members of my family. So 4 plus 4 people, you prepare nice, a lavish and a happy and a sumptuous meal. You incur that expenditure and you get ready on the table. Finally, I tell you, oh, I'm so sorry, there's something that happened and I cannot turn up. So the question is, can you file a case against me for not turning up for the dinner? So the answer to that is, this is a social agreement. So family and social agreements between each other, it does not create, or friendly agreements, does not create a legal obligation. So therefore, you cannot sue me for damages. And in this example, A cannot sue B for damages. Why? That is just a social and a friendly agreement. It has not created a legal obligation. So therefore, it is not a contract. It has not created a legal obligation. There is no enforceability here. There's no enforceability. So therefore, it is not a contract. So what is an offer? In Storer versus Manchester City, this is a case law. This is a classic case law. In Storer versus Manchester City Council 1974, the court set forth that offer is an expression of willingness to contract on specified terms with the intention that it is to be binding once accepted. So an offer is a proposal to enter into an agreement. An offer is also defined as a promise that one party makes in exchange for another party's performance or for consideration. So offer involves 2 parties, the offerer and the offeree. That is the one who makes the offer and the one to whom the offer is made. So question comes, what is an offer? It is defined as a promise that one party makes in exchange for another party's performance or for consideration. An offer involves 2 parties, the offerer and the offeree. That is the one who makes the offer and one to whom the offer is made. To constitute a valid offer, the following elements must be present. 1, the offer must be communicated. Like for example, I have something in mind to be sold to you. I want to sell something to you. Okay, I have it in my mind. I'll say, okay, fine, I want to sell a piece of property to you. And I know that you're interested in that piece of property, but I don't communicate to you. Is it an offer? It is not an offer. Why? Because it is not communicated to you. So a valid element that must be present in a valid offer is that it must be communicated. with the intention to create legal obligation. If it has to be a legal offer, then it must be communicated with the intention to create legal obligation. For example, Y's father promises that if he passes his examination, he will reward Y with a brand new car. Y passes the exam and reminds his father to give him the gift as he had promised to Y. Here, the father is not legally bound as the offer was not intended to create a legal obligation. Why? This is a family social obligation. Now, in case of Balfour versus Balfour, this is a classic case and it is a landmark decision rather, and it must be there in your answer books. It must be there. Put a star there for this. Balfour versus Balfour, 1919. It's an old case, King's Bench. KB is King's Bench. Those days. It's an English case law, common law. Husband promised his wife to send 30 pounds per month. Subsequently, husband failed to do so. The wife filed a case against him, and the court held that there was no intention to create a legal relationship. Thus, the agreement was not valid. And the third element for an offer to be valid must be clear, definite, and unambiguous. That means there has to be clarity. It has to be clear. There should be no multiple interpretations. It should be unambiguous. That means it should be free from all ambiguities. So there is a distinction between an offer and an invitation to treat. And this is important. There is a difference or a distinction between an offer and an invitation to treat. And the distinction mainly lies in the intention of the parties. Example, tender. There are commercial tenders. So tender is an example of invitation to treat because when tenders are invited, bidders are examined, and of it, the best bidder is shortlisted. And finally, out of the shortlist, one bidder is awarded the tender, and then there is a subsequent contract. Sorry. So an invitation to treat implies that a person is willing to enter into negotiations, but may not be willing to bind himself to a valid contract. So for an offer to be considered a valid offer, it must be shown that the offerer had the intention to be bound and the intention to create a legal obligation. Again, a landmark decision in this area is Harvey versus Fassett. You ask any student of contract law, Balfour versus Balfour, Harvey versus Fassett. These are some of the case laws, or even there is yet another case law that's coming down the line that is okay, we'll deal with that later, of course. So, for example, Harvey versus Fassett, Balfour versus Balfour. Do not want to confuse you here. So, these are some of the case laws that must be present in your answer books, and these are some of the cases that we never forget throughout our life. Like even if you're sleeping and you're fast asleep, and someone wakes me up and asks me, "Okay, what's Balfour versus Balfour?" I will tell you, "Oh, Balfour versus Balfour is this case." And if you ask me, what's Harvey versus Fassett, I'll say, "Oh, Harvey versus Fassett. That's an old case, Privy Council's case." Okay, these are the facts of the case. So a contract law student, and a law student for that matter, will never forget certain landmark decisions. And this is one kind of a case law that should not be forgotten by any student of contract law, Harvey versus Fassett. Now, what are the facts of the case? Now here, sorry, Harvey sent a telegram. Those days there was this telegram system. Harvey sent a telegram to Fassett, which stated, "Will you sell us bumper whole pen?" That was a property. He sent a telegram to him saying, "Will you sell us bumper whole pen?" And he said, "Telegraph lowest cash price. Answer paid." So this was a telegram contents. So Fassett replied by telegram saying lowest, because those days word to word it costs. I'm sure you know what's a telegram. Word to word costs. That is send telegraph message. So even a comma costs, a full stop costs. So the way they used to send telegram is like, a short, kind of a very short message, which intends to communicate, the entire message. So he sends, will you sell his bumper hole pen? Telegraph, lowest cash price, answer paid. So Fassy replied by telegram saying, lowest price for bumper hole pen is £900. So Harvey then replied again, we agree to buy bumper hole pen for the sum of £900 asked by you. Please send us your title deed. What's a title deed? The ownership papers. The title deed, the ownership papers of a particular property. So please send us the title deed in order that we may get early possession. Now here, the Privy Council held that there was no contract concluded between the parties. Fassé had not directly answered the first question as to whether they would sell, and the lowest price stated was merely responding to a request for information and not an offer. Thus, there was no evidence of an intention that telegram sent by Fassé was to be an offer. Therefore, it can be considered as an invitation to treat and not an offer. Next landmark decision is Carlyle versus Carbolic Smoke Ball Company, decided by Queen's Bench, QB, Court of Appeal. Carlyle versus Carbolic Smoke Ball Company. So here we have learned thus far two case laws, Balfour versus Balfour, Harvey versus Fassé, and the third one now is Carlyle versus Carbolic Smoke Ball Company, Queen's Bench. Here, a newspaper advertisement was placed by the defendant who stated, £100 reward will be paid by the Carbolic Smoke Ball Company to any person who contracts the influenza after having used the ball 3 times daily for 2 weeks, according to the printed directions supplied with each ball. So this was basically a company where they produce certain medicines and certain tablets. They said that if you take those tablets, a person will never get influenza. If you take these tablets, like how you have COVID, right? It had come up recently, and how we have these vaccines and all that. So those days, to avoid influenza, they had kind of a medicine, and they said if you take it 3 times daily for 2 weeks, so a person would never, the consequence of influenza would not be very bad. So a person who contracts influenza after having and it wouldn't come, and rather it wouldn't come, and even the consequence wouldn't be bad. It wouldn't come. It's like it's something that deters a person from contracting influenza. That is like a shot. It was like how you have this COVID vaccine. So this particular tablets, which referring to the word use those those days. Like even today, you have these what they say, homeopathic medicines. Yeah. So the pills. So if you take those pills 3 times a day for 2 weeks, according to the printed direction, that means you must go as per the directions of the company. So the person who takes these pills will never contract influenza, or even the effect might be mild. So what they did was, if at all, they challenged, they said, if at all you contract influenza, then we are going to give you £100. So just as a safety, they deposited £1,000 in Alliance Bank, and expressing their sincerity in the matter. Now, what happens? There was a customer, Mrs. Carlyle. She purchased some smoke balls. She purchased those pills, and she used them according to the directions, and then finally caught flu. So what she said, yes, now I've already caught flu. I'm sick with flu now. So your claims did not work. So what she did was, she sought to claim £100 reward. Then the company, Carbolic Smoke Ball Company, raised the following arguments and defense points to demonstrate that advertisement was a mere invitation to treat rather than the offer. So they come up with their defense points, their defense mechanism, saying, so, well, this was not a legal offer really. This was just an invitation to treat. So they said that the advertisement was a sales puff, and it lacked the intent to be an offer. Then they said that, well, it is not possible to make an offer to the world. How it's possible? I make the offer to the entire world. It's practically impossible. Then there was no notification of acceptance. Why? Then they said that, well, there's a question of agreement here. Offer plus acceptance is an agreement. How could I understand that you have accepted the offer? I mean, it's just only defense points. Remember, these were the defense points put up by Carbolic Smokeball Company. Then they said the wording is too vague to constitute an offer since there was no stated time limit as to catching the flu. And there was no consideration provided since the offer did not specify the user of the balls or the pills must have purchased them. Let's see what the court decided. The picture that you can see on the screen, this one, I'll just try to make it big. You can see here. This picture is the original advertisement. This is the original advertisement way back in 1800s. This is an 1800 case. Way back in 1800, this is what it looked like. And it appeared in the Illustrated London News at 263. Okay, so this is how it looked like. So the matter went up to the stage of appeal. Long story short, and the appellate court held that Mrs. Carlyle was entitled to the reward as the advertisement or the advert constituted an offer of a unilateral contract, which she had accepted by performing the conditions stating in the offer. There was this conditions which were there, that is how the medicine has to be taken, and you have to take 3 times a day. And she went according to the printed directions and so on. So she went by that. And so they said that indeed the concept of offer was reflected. You could call it as a unilateral contract. It's an open offer. So this is what the court held. And the appellate court rejected all the arguments put forth by the defendant, that is the earlier arguments that we were talking about. These arguments, they said that the advertisement was a sales puff. It's not possible to make an offer to the world. There's no notification of acceptance. So all these points were, rejected by the appellate court on the following grounds. What was those grounds? Or what were the reasons? The statement referring to the deposit of 1,000 demonstrated intent, and therefore it was not a mere sales puff because they went and did deposit 1,000 pounds as a safety in the bank, Alliance Bank. Then it's quite possible to make an offer to the world. That is how? Through advertisements. In unilateral contracts, there is no requirement that the offeree communicates an intention to accept, since acceptance is through full performance. And whilst there may be some ambiguity in the wording, this was capable of being resolved by applying a reasonable time limit or confining it to only those who caught flu while still using the pills or the balls. Those days they referred to it because it was a kind of a medication which was round pills. So the defendants would have value in people using these medications even if they had not been purchased by them directly. So this was the rationale behind the appellate court's judgment in awarding or decreeing in favor of Mrs. Carlyle, and Carbolic Smokeball Company lost the case. So this is it. Today we have learned about the general aspect of what constitutes an agreement and what's a contract. But we just spoke about in detail only what is an offer, right? We are just here, offer. Offer plus acceptance is an agreement. So next class we will learn about what is acceptance. So any questions here?